Thank you for joining Elite Specialty on today's discussion regarding employment practices liability. We wanted to update you on the state of the rapidly changing EPL marketplace affecting insureds in California and throughout the United States. This presentation is brought to you by Elite Specialty and Wholesale Insurance Services. My name is Greg Lyons, and leading today's webinar is my colleague, Luke Hutchinson. Throughout today's webinar, we will provide context behind why the market is changing, including rate increases following years of depressed rates, capacity reductions, social inflation, and nuclear verdicts due in part to litigation funding, constantly evolving legislation surrounding COVID-19, and management liability claims resulting from decisions on how businesses reopened following government-implemented lockdown orders. We will turn the reins over to Luke to get us started.
Thanks, Greg. In our last webinar, Greg covered the reasons behind the current hard market impacting the entire insurance industry. We highlighted the fact that the hardening began some time ago for certain segments of the industry, including management liability lines, which started firming up in Q2 of 2019. As we head into the third quarter of 2020, several factors have led to a rapid escalation in pricing and a reduction in capacity. Prior to the COVID-19 pandemic shutting down large sections of the global economy, underwriters were already dealing with years of depressed rates due to a competitive marketplace supported by virtually unlimited financial resources. Unfortunately, claims verdicts have been outpacing actuarial projections, spurred in part by litigation funding. The combined ratio in management lines has been well over 100%, and in some cases, upwards of 150%. Employment practices has been among the hardest hit, and as a result, carriers are increasing rates anywhere from 5 to 25% on clean risks and in the triple digits for those with recent claims. Additionally, classes of business that historically have been considered low hazard are now forcing carriers to rethink their stance. These include some of the hardest hit during the initial stages of the COVID-19 pandemic, including restaurants, manufacturing, and airlines. While there are several bills proposing liability shields for employers on the state and federal level, these industries are expected to experience some of the highest volume in claims. Even with a legal shield from COVID-19 claims, employers will still have to face potential claims from employees claiming discrimination over wrongful termination, wage and hour disputes, and potential privacy concerns over contact tracing. All of these complex issues will contribute to expected rate increases over the next 12 to 18 months. In addition to the rate increases, carriers have begun reducing capacity, with some markets cutting their limits by up to 50% at renewal, forcing agents to look for multiple carriers just to offer expiring limits. We've had clients wondering what the reasoning is for limiting capacity if the insurers are obtaining adequate rates based on exposures. Part of the issue can be attributed to reinsurers who are coming off 3 consecutive years of poor performance tied to global catastrophic losses, including hurricanes, wildfires, and earthquakes. This has forced many of them to reevaluate their portfolios as they struggle to maintain solvency ratios, being closely monitored by rating agencies including Fitch and AM Best. Beyond concerns driven by higher than normal losses, global reinsurers will fail to earn its cost of capital in 2020 amid the coronavirus crisis, which will help maintain price increases for the sector during the year ahead. It is expected their financial performance will be hit hard by mortality claims and losses from event cancellation, business interruption, credit and surety insurance, as well as by financial market disruption connected to the economic impact of lockdown measures. While the pandemic has certainly been a recent issue, we can also look at Lloyd's Decile 10 initiative, which began back in January 2019. It has also contributed to a reduction in available capacity as syndicates have looked to reduce or run off the poorest performing portions of their books, which are often tied to cat loss prone lines of business. Management lines, impacted by an increase in claims frequency coupled with severity, driven in part by social inflation litigation funding, were included in several syndicates' Decile 10 initiative. So what is social inflation? What are nuclear verdicts? And how has litigation funding driven it forward? Last year, a large pharmaceutical company was hit with an $8 billion verdict by a Philadelphia jury, an amount that exceeded the gross domestic product of more than 60 countries in that same year. In fact, pharmaceutical companies have become the poster children for what many in the legal industry refer to as nuclear verdicts. These are jury verdict awards in the hundreds of millions and billions and are becoming more and more common in American trials. The impact of this upward trend in verdicts is often referred to as social inflation and has become a popular topic that has understandably caused panic within the insurance industry. In short, social inflation and nuclear verdicts demonstrate that a standard economic analysis for assessing risk in litigation is no longer sufficient for accurately predicting potential risk. An example, under a standard economic analysis, the value of a car crash should be no different in 2019 than it was in, say, 2007 for a similar plaintiff beyond the adjustment for standard inflation, and certainly no different from a similar injury in a similar 2019 case. But that is not what we are seeing with jury verdicts. Instead, they are wildly erratic and inconsistent. In short, the data on jury verdicts demonstrates irrationality at work. There are widespread and differing beliefs about the cause of nuclear verdicts. First and foremost, it is important to recognize that nuclear verdicts are born out of juror frustration and anger. These verdicts are always designed to send a message. While there's no consensus on when it began, there are 8 key factors that drive nuclear verdicts. Number 1, the growing economic divide. One of the most prominent narratives in the American socio-political landscape is the growing economic divide between the haves and the have-nots. Then there's growing distrust. Data published by Pew Research Center in 2019 shows that trust in both institutions and individuals has significantly declined across the board. There's the polarization of America, with new research out of the National Bureau of Economic Research shows that political polarization has risen more quickly in the United States than any other country studied, whereas in other countries, it is actually on the decline. Then we have outrage culture and declining tolerance. In a 2017 piece in the Huffington Post, the author declared, and I quote, "Productive discourse is dying, trampled over by closed minds who value comfortable opinion holding over uncomfortable soul searching. As dialogue lies flailing and gasping, outrage culture's pulse is stronger than ever. We see the degraded consequence everywhere," end quote. We have the normalization of nuclear verdicts. In short, we're seeing more and more of them in our headlines, which without a doubt has an anchoring effect on angry and frustrated jurors. A verdict in the hundreds of millions and even billions no longer seems out of the question with jurors who routinely see news reports of similar verdicts in their trials. Beliefs versus facts. A national survey conducted by Sound Jury Consulting in 2019 found that 75% of jury-eligible respondents said they would decide a case based on their own personal beliefs of right or wrong if those beliefs conflicted with the law as instructed by the judge. If we take that data and narrow it to just millennials, the percentage increases to 82%. However, the problem is not uniquely tied to millennials alone. The fact is that we are evolving into a me-first culture defined by an extraordinary tendency towards motivated reasoning, where our beliefs drive what we are willing to accept as facts and law. Then there's a new generation of jurors. We can blame it on too many participation trophies or blame it on helicopter parents who insisted their child was particularly special and unique. There are endless theories about why millennials are so different from other generations and equally expansive research on the specific differences. And number 8, lawyers' failure to adapt to emerging learning styles. And while this is certainly not true of all, but it is true of many. Many attorneys will tell you that they are open to new perspectives and express genuine interest in them, but return to their old ways when it comes to actual execution. And while these 8 points are certainly at the top of the list, I would argue there may be a more specific singular factor: litigation funding. For those unfamiliar with litigation funding, also known as legal financing and third-party litigation funding, basically it enables a party to litigate or arbitrate without having to bear the upfront expenses, whether because they're unable to pay or because they do not want to. It's up to them. A third-party professional funder can pay some or all of the costs and expenses associated with the dispute in return for a share of the proceeds of the dispute if it is successful. If the litigation is not successful, the funder bears the cost it has agreed to fund. Litigation funding has two major divisions: consumer financing, commonly referred to as pre-settlement funding or plaintiff advances, and commercial financing. Consumer financing generally consists of small advances between $500 and $2,000, whereas commercial financing for companies is to pursue legal claims generally dedicated towards payment of attorney fees and litigation costs. Litigation funding provides plaintiffs the financial security to take claims to trial, where in the past, they likely would have accepted a pretrial settlement at a substantially lower amount and with reduced litigation expenses. An example of litigation funding pushing claims forward can be found in the Time's Up Legal Defense Fund, offering reduced attorney fees or free consultation and, in certain circumstances, trial funding. It has been suspected that several prominent Me Too cases have also been backed by litigation funding. The Harvey Weinstein case may be one of the most well-known stories to come from the Me Too movement, with annual payouts for sexual harassment having now exceeded $100 million in the last 3 years. And while these sensitive subjects with valuations tricky to navigate, a road rage incident in Oregon with a $26 million payout should seem high when the same payout in the same court, the same loss in 2007 was only $1 million. With the coronavirus stifling court systems, there has been speculation the tides of social inflation will begin to recede as plaintiffs and attorneys suffering from economic challenges feel the pressure to accept settlements. The alternative is to wait out the courts, which in reality may be at 12 months out, or as more pressing items take the court's time and limited resources. And while employers are no strangers to sexual harassment and other EEOC laws, recently passed legislation has not been favorable to employers in 2020, starting with the enactment of California Bill AB 5, better known as the Gig Economy Bill. The Gig Economy Bill, among other items, deemed contract workers qualify as employees if they are performing the same type of work as the company for which they are performing the work. A prime example being Uber and Lyft. As a result, workers have begun to file claims for lack of sick leave and putting drivers at increased risk of exposure similar to frontline workers. We've also seen states suing companies such as Uber and Lyft for misclassifying their employees. Then came March, and as a response to the coronavirus was the creation of the Families First Coronavirus Response Act, the FFCRA, one of hundreds of new laws keeping COOs and HR departments awake at night. The FFCRA includes provisions for emergency paid sick leave for employees directly infected or for employees taking care of family members who have been infected with the coronavirus. It also stipulates employers must accommodate employees with children who require leave to care for them. And while it appears schools will be reopening in the fall, it is still uncertain to what extent, which presents employers with additional hurdles when it comes to handling employees with children who are in part-time distance learning. Additional potential claims we're watching out for include improper designation of individuals as healthcare providers or emergency responders, questions regarding allowance and calculation of intermittent leave and correct pay, retaliation claims, and whistleblower claims as previously loyal workers who were furloughed or laid off throw their former employer under the bus. Another area of concern for employers is implementation of employee screening. The testing for symptoms will place a burden on employers, especially in California, who are already walking a fine line. Determining who will be responsible for taking employee temperatures and how they communicate with potentially infected employees opens up several areas of concern. Then there's the contact tracing. Part of the CDC's return to work guidelines includes contact tracing for employees who test positive for the coronavirus. Beyond the personal concerns, requesting contact information can lead to health privacy concerns for both the employee and their recent contacts. As you can imagine, employers are getting concerned about potential litigation around employees' scope of work and travel destination, wage and hour issues, for example, whether employees should be compensated while getting tested or passing through screening, employee leave policies, travel restrictions, telework protocols, and workers' compensation. In addition, employers fear they could risk legal actions if they do not accommodate employees who insist on returning to work, even though they have not completed health screenings or are high risk. Employers fear legal exposure for not following all procedural requirements. They have to lay off workers, especially in response to social distancing policies and government mandated closures. With all the legislative changes coupled with socioeconomic changes, employers are having to contend with quickly evolving legislation, and in some cases are being forced to make hurried decisions regarding their workforce. That reads as a recipe for potential FFCRMA, FMLA, ADA, you name it, EEOC claims, along with a huge uptick in retaliation claims. EEOC charge filings are expected to increase, specifically age discrimination claims, including which employers an employer elected to lay off or furlough and bring back, and then what decisions went into determining which employees were selected. And with the stark decline in revenues prompting workforce reductions, companies will need to review the work being performed by exempt employees to ensure it does not fall into the class of a non-exempt employee, which would open up a potential wage and hour claim tied to overtime. Speaking of overtime, this is yet another area where employers are facing new regulations. With an influx of employers allowing work from home, the potential for employees to work off the clock becomes a tough item to control and will surely be scrutinized by opportunistic plaintiff attorneys. And while the courts have been relatively quiet, litigation will pick up once they reopen. Plaintiff-side law firms have been putting on free webinars to encourage employees to sue, and the cases are starting to stack up. We expect an increase in whistleblower claims, especially as employees claim inadequate safety measures taken by their employer, along with being in violation of potential stay-at-home mandates, which is already happening. As mentioned earlier, previously loyal employees may no longer withhold frustrations from their employer following layoffs or changes to the work environment, walking away from their prior place of employment with the whistle ready to blow. We're watching for discrimination claims, specifically employers who conduct a medically based or risk-based reopening, such as using age or underlying health conditions. They may face liability under the AIDS Discrimination in Employment Act and the anti-discrimination provisions of the Americans with Disabilities Act. At-risk employees who are denied a request to work from home due to the job not being able to be performed remotely may also file a claim due to unreasonable accommodations. And for those that have actually been granted accommodations to work from home, their employers still may face claims arising from their failure to accommodate the home worker with an ergonomic workstation. And last, for those who do return to the office, any changes in the work environment or how things are customarily done, such as restricted building access, requiring temperature checks, treating people as disabled even if they're not, breaking confidentiality of employee health records. These are all areas that fall under the ADA and may end up in a retaliation type suit or retaliation claim, depending on the employer. We'll tell you, with such rapid changes to employment laws, it is imperative for your clients to stay up to date on all best practices. As you review new and renewal quotes, be sure to closely review any new or updated policy forms, as exclusions tied to many of these new laws are already beginning to appear.
Thank you for joining Luke and I on today's presentation. We hope you found this information useful. Please feel free to contact us if you or your clients have questions on management liability, including employment practices. Have a great day.